everyone, and welcome to this video tutorial on remedies in contract law. Remedy is a solution in a civil case, and it's an award made by the court to the innocent party. And there are two types of remedy that may be awarded: the common law remedy of damages, and there's also a variety of equitable remedies available. This diagram shows the two types of remedies available for a breach of contract. We've got the common law remedy of damages, and we've got equitable remedies, and you can see that there's a number of these listed here. We've already come across the common law remedy of damages before when we were studying tort. Damages in contract law are a legal remedy available for breach of contract. Damages are an award of money to compensate the innocent party. The primary purpose of damages in contract law is similar to tort. The idea is that we place the injured party in the position they would have been in had the contract been performed. Equitable remedies, then, are judicial remedies which were developed by the courts of equity from about the time of Henry VIII. And we've got here a number of different equitable remedies. Injunctions we've come across before when we've been studying tort, but specific performance, rescission and rectification are new to us. The reason this diagram separates equitable remedies from the legal remedies is that legal remedies, such as the common law remedy of damages, are available to the claimant as of right or automatically, if you like, whereas equitable remedies are at the discretion of the judge. So the judge can award these if he wants to, but he doesn't have to. To start with, let's have a look at the common law remedy of damages then. So we know that there is a sum of money paid to compensate the innocent party. They are available as of right, as long as we can show that the contract had been breached. And the idea is we're trying to put the claimant back in the position they would have been had the contract been performed. There are different types of losses, and we've seen this with tort before, that if a contract's breached, the party may suffer pecuniary or financial loss or non-pecuniary loss. Financial losses such as loss of profit are going to be much easier for the court to calculate, whereas non-pecuniary losses, which if you recall from tort, are much harder to put a financial figure on. Because in tort, non-pecuniary losses were things like loss of amenity, compensation for pain and suffering, so not easy to put a figure on. Non-pecuniary losses in contract law are things such as mental distress, disappointment, hurt feelings. Traditionally, you couldn't get any damages for these under contract law, but the rules have been relaxed somewhat for contracts which were taken out specifically for pleasure, relaxation and peace of mind. So for non-pecuniary loss in contract law, the general rule is that you can't claim for mental distress alone. And that comes from the case of Addison Gramophone from 1909, where the court clearly said that damages for mental distress are not available in commercial contracts. Some years later, in Watson Morrow, we've got a quote here from Bingham Lord Justice, and he says that a contract breaker is not liable for any distress, frustration, anxiety, displeasure, vexation, tension, or aggravation, which his breach of contract may cause to the innocent party. So he's making the point that when a contract is breached, you might suffer all of these negative feelings, but in general, you can't get damages for that in contract law. But he goes on to say that the rule is not absolute. And where the very object or purpose of the contract is to provide pleasure and relaxation, you can receive some damages to make up for that. And we'll have a look at a case which illustrates that point. Jarvis and Swantors is an example of a case where a claimant was successful in claiming non-pecuniary damages for disappointment in contract law. And that's quite unusual. If we have a look at the facts, Mr. Jarvis was a solicitor who booked a 15-day skiing holiday over the Christmas period with Swantors. And the brochure made several claims about the enjoyment relating to house parties, a welcome from an English-speaking hotel owner, lots of different ski runs, afternoon tea, cakes, and most exciting of all, a yodeler. Many of these events didn't go ahead or weren't as described, and so Mr. Jarvis wanted to claim some damages based on his disappointment. Now, the general rule from Addis and Gramophone is that you can't claim for this sort of disappointment, this mental distress in contract law. However, he was entitled to claim because the court said that his contract was entered for the specific purpose of enjoyment and entertainment, and therefore he could claim some damages for his disappointment in not receiving that entertainment. Foley and Skinner is an example of where the claimant was successful in suing for non-pecuniary loss, this time for discomfort. And the facts here was that Farley contracted with Skinner, a surveyor, for Skinner to survey a potential house for aircraft noise because it was near an airport. Skinner said that the aircraft noise was unlikely, but after moving in, Farley discovered that Gatwick Airport had been expanded and it was actually very noisy indeed. Farley was able to recover £10,000 for discomfort, and the court said that damages could be recoverable for the loss of a pleasurable amenity which may be of no economic value if they are of importance to the claimant. And the judge in this case, Lord Scott, said that if Mr. Farley had known about the aircraft noise, he would not have bought the property, so it was right that he should get some damages for his discomfort in this case. There are some limitations on awarding damages, and an award of damages in contract law is subject to the application of the rules on causation, remoteness, and mitigation of loss. Causation then, we've got the case of Quinn and Birch brothers. Quinn was a builder subcontracting to Birch, and Birch was in breach of his contract by not supplying a stepladder to Quinn because he was supposed to supply all the equipment. To prevent delays, Quinn used a trestle table which he knew wasn't suitable, and he stood on it and it moved and he fell and was injured. And he's trying to claim compensation, damages for his injury as a result of this breach of contract. It was held that Birch's breach of contract provided the opportunity for Quinn to injure himself, but was not the cause of his injury. The court said that the injury was caused by Quinn's own voluntary act in using the trestle. So the principle is that the breach of contract must cause the losses. A voluntary act of the claimant can break the chain of causation. So this is similar in a way to victim's own act when we've looked at causation in criminal law, that really Quinn was daft in using this trestle table, so he's broken the chain of causation. Obviously, we don't want to bring criminal cases, though, into contract law, but that's just so you understand what's happened here. The remoteness, the key case here is Hadley and Baxendale. And in this case, the crankshaft broke in the claimant's mill. So the claimant contracted with D to deliver the crankshaft to the repairers and bring it back fixed. The defendant promised to deliver within a day, but the defendant was delayed and returned it 7 days late. And our claimant was unable to use the mill during this time, and he was claiming against the defendant for his loss of profit. The defendant argued that he was unaware that the mill would have to be closed during the delay, and therefore the loss of profit was too remote. And the court actually found for the defendant and said that he was not liable for the loss of profits because they were too remote, and that the defendant had not reasonably foreseen the consequences of the delay because the claimant had not informed him, so he shouldn't be liable for the mill's lost profits. In this case explained that the mere fact that a party is sending something to be repaired doesn't necessarily indicate that the party would lose profits if it's not delivered on time. So the claimant should have made it clear to the defendant that he needed that in order to work, and he would lose profits if there was a delay. So our principle here is that our defendant will only be liable for losses that were reasonably foreseeable to the defendant as arising from the breach. Another key case on this same point of remoteness is a very important case, Victoria Laundry, and this situation frequently comes up in scenarios, so look out for it. And what happened here was the claimant purchased a large boiler for a laundry business, and the defendant was aware that they needed this boiler for the nature of their business. The delivery of the boiler was delayed, and the claimants brought an action for loss of profit. and the claim also contained a sum for a particularly lucrative contract. Now, in this case, the claimant could claim damages for the normal loss of profits because the defendant was aware of the normal nature of their business, but they were not able to claim for the losses relating to this lucrative contract because the defendant had no idea that this lucrative contract existed. So you need to make the defendant aware of any lucrative contracts which are going to be impacted by any delay. There is also a duty on the claimant to mitigate his loss, as we've seen in tort law, so they can't sit back and allow their losses to increase. They have to try and keep losses to a minimum. And that's illustrated in Pilkington and Wood. In terms of calculating losses, the claim can be based on loss of expectation or reliance loss. Reliance loss is illustrated in Anglia TV, where Anglia TV incurred expenses when Oliver Reed pulled out of a TV show. And they were able to recover expenses that were incurred by relying on the contract. That's what reliance loss is. So they were able to receive damages to put them back in the position they would have been before the contract had been made. Loss of expectation is illustrated in Golden Victory, and it says here in this case that the claimant will have expected a certain result from the contract, so damages for loss of expectation will compensate for this. And you can see here the different ways that the court quantifies the loss of expectation. As well as damages, we've seen that there are also equitable remedies, and equitable remedies are used where damages are inadequate to compensate the claimant. Come across injunctions before. An injunction is a special court order that compels a party to do or to refrain from doing specific acts. A locutory or interim injunction is an injunction that's put in place until the court hearing, so if that's at some point in the future. Prohibitory prevents the defendant from doing a particular action. Mandatory compels a party to do something. And in the case of Warner Brothers, the principle was that a defendant can be given a prohibitory injunction which compels them not to do something as well. Specific performance is an equitable remedy whereby a court issues an order requiring a party to perform a specific act, such as to complete performance of the contract. It's typically available in the sale of land, but otherwise it's not generally available if damages are an appropriate alternative, and specific performance is almost never available for contracts of personal service because, as you can imagine, you don't want to force somebody to complete a service. You can imagine what difficulties that might bring. And you can see here Bezic and Bezic saying that specific performance only available where damages would be inadequate. Walters, only where the contract has been made fairly. And in Patel, it must not cause a great hardship or unfairness on the defendant. So the court's fairly reluctant to use specific performance. Rescission is an equitable remedy which allows a contractual party to cancel the contract. And parties may rescind if they are the victims of a vitiating factor, such as misrepresentation, economic duress, which we've come across before. And rescission is the unwinding of a transaction, and it's done to bring the parties as far as possible back to the position in which they were before they entered the contract. Rectification is a remedy whereby a court orders a change in a written document to reflect what it ought to have said in the first place. It is an equitable remedy, so the circumstances where it can be applied are limited. Remember, this also treads on the toes of freedom of contract. We don't really want judges to be rewriting contracts, so we need to be careful about how rectification is used, but it was used in the case of Craddock and Hunt. And here you can see rectification was ordered to correct a mistake in the sale of a property. To summarise then, we've looked at the common law remedy of damages, the reluctance on non-pecuniary losses, the normal rules of causation, remoteness and mitigation of loss, and also be aware of equitable remedies which are at the discretion of the court.